So we had the right to strike. Purpose of that was that if something frivolous happened, fine, and it wouldn't necessarily be a wildcat strike, it's a work stoppage. And that kept a lot of things, so you didn't have these frivolous things, well, you have to do this, no, I shouldn't have to do those kind of things. We went to grievance and arbitration. And what happened was that sometimes an employer would push, say, well, we're doing this anyway, just grieve or arbitrate, which caused, which I brought up many times before, the unions to police themselves, because if an employee is guilty, they're not going to go to a $20,000 or $30,000 arbitration case and lose. So we would police ourselves. Does the arbitration you're talking about here work the same way that ours did? There'd be like a pool of 3 arbitrators, and the sides would have to agree, like I picked this one, I picked this one, and the arbitrator would then be picked that both sides could pretty much agree to?
Well, this bill does not specifically address that, but it would not change the way that it's done now, and that is parties select the arbitrator, and sometimes it's specified in the contract, the employment contract, on how that's going to be selected. Sometimes it's a process, like other alternative dispute mechanisms like mediation, where one party, as you mentioned, selects one or more arbitrators that they may want, and the other party selects some that they may want, and then they come to a mutual agreement. And really the whole idea of arbitration agreements is just that. It's to honor an agreement between the two of us. And so this would not change that aspect, that the parties would still mutually agree to who the arbitrator is. And generally those, in fact, most contracts call for arbitrators to be certified under the American Association of Arbitrators, and so they're certified, they're qualified, they're often people that have had litigation experience extensive in that field, or previous judges in that field.
A lot of them are, I think, probably by and large, attorneys that have that kind of experience. Right. And the thing I was getting at, the reason I asked that is because living through some of these situations when you get hurt on the job, and you go to a clinic, and I mean, my God, some of the doctors you run into say you can go back to work, and you're not ready to go back to work. And that's just what I was concerned about with this arbitration. If it's done through standard procedure, that would be fine. The last question I have is, I know we have several representatives who are in business for themselves. I know a lot of people that are in small businesses. And I think that arbitration can be abused by either side. And if you get, say, a troubled employee that just wants to continually go to arbitration, and it could cost particularly a smaller business, a lot of money, which is not fair either. Are there checks and balances in the system where that doesn't happen? Because again, smaller employer, they're operating on a small margin of profit, and we ran into this in the school district. Custodians and bus drivers and maintenance folks were at-will employees, but there was no contract signed. They were merely hired, meaning at will. And we would arbitrate if it got to that point. But if you get a troubled employee, I mean, that could be a real pain in the side for a business, particularly a small business.
Right, Representative, I understand that. This bill does not necessarily direct that particular issue, except from the standpoint of this. Arbitration agreements generally are more cost-effective and efficient, and so although this doesn't necessarily this in fact does not take away an employee's right to be able to take an issue and challenge it and have a dispute with their employer, but this does provide, though, that it will be done in the most efficient mechanism and cost-effective, so that if in cases of, you mentioned, of continual going to arbitration, you're certainly at least not incurring the costs that you would in court, which would be more.
Okay. Thank you very much. Thank you, Mr. Chairman.
Do we have those here to testify in support of this bill?
Thank you, Mr. Chairman, members of the committee. Pleasure to see you again. Jay Atkins, registered lobbyist and general counsel for the Missouri Chamber of Commerce and Industry. We are happy to go on record in support of this bill. We appreciate working with Representative Corlew on this, and and are happy to lend it our full support. Arbitration agreements in employment contract are an important tool for Missouri businesses to help lend some predictability and control the cost of their business, be they a large business or a small business. And when they enter into a contract with an at-will employee that contains an arbitration clause, they're relying on that predictability that is built into the contract. The reality is Missouri is an outlier among states and nationally. Most courts in most states look favorably upon alternative dispute resolution as a means of resolving any number of disputes, but chiefly between contracting parties and also in the employment context. So the fact that we are even here today speaks volumes about the state of Missouri's courts. We are one of the very few, if not the only state that has seen this pattern emerge recently of courts refusing to enforce arbitration clauses in contracts. So we'd like to fix that problem. We would like to see a world where the arbitrator gets the first bite at the apple to determine whether or not a contract an arbitration clause is enforceable. I would ask members of the committee to bear in mind, I'm not sure if the representative touched on it or not, but upon the completion of the arbitration process, it's important to note that those final agreements are subject to review by the appellate court should one party or the other choose to seek that review. So we're not foreclosing the opportunity for either the company or the employee to seek further review should the arbitration end adverse to one party, a particular party, but we are asking that the arbitration process that has been contracted for be allowed to go forward first. So I'm happy to answer any questions and happy to go on record supporting this bill.
Thank you, sir. Are there those here in opposition to the bill?
Good afternoon, Mr. Chairman, Committee. My name is Amy Koopman, and I'm here on behalf of Kansas City National Employment Lawyers Association. I'm also a plaintiff side employee attorney in Kansas City with the law firm Boland Rickens. And I appreciate your time this afternoon so that I may go on the record in opposition to the bill. I want to be really clear about what we're talking about. I'm not here to say all arbitrations are bad. I don't think that. But this bill is specifically saying that arbitrations in the employment context, when an employee is having a dispute with their employer, will be given special footing in the arbitration world according to the terms of the bill. And there are lots of reasons why that shouldn't happen. And so I appreciate some of the earlier comments about various contexts for having arbitrations, but we got to think about it in terms of who are the parties to the arbitration. When we talk about, well, this is a fair environment where the parties are making decisions together collectively, and it's a cooperative thing that's efficient and it's more time saving, all those things. That's true if you're talking about one business arbitrating with another business. Or one CEO arbitrating with another CEO. They're on equal footing. But if you have an individual employee who perhaps has worked somewhere for years, and one day they come to work and they say, you need to sign this. Well, what does it say? Well, sometimes they get the chance to read it, sometimes they don't. But in the end, what they're being asked to do is sign away their right to have their disputes heard in a court of law if later on they do have a problem with the employer. And in order to keep their job, they have to agree with that. Those are not equal bargaining positions, right? And that's why it's unfair in this setting. And unfortunately, this bill focuses on employment context. So I want to make a distinction between arbitration versus forced arbitration, which is exactly what this is. We've got to think about who the arbitrator is, not just who are the parties, but who's the arbitrator. In this setting, you've got someone deciding a dispute who is paid sometimes several $100s an hour, either an individual arbitrator or even maybe a panel of several arbitrators, to decide these disputes. They have a financial incentive to not only go through the arbitration, but also a tendency to side in favor of the party that's giving them repeat business. So think about that again. In the employment setting, who's the party that's typically going to see an arbitrator in the future? Who's going to have another arbitration down the line? It's going to be the company. The employee will probably never arbitrate again. And so there is, both on the front end, if you're saying, let the arbitrator decide whether it's a fair arbitration agreement or not, they obviously have an incentive to say that it is, because if they go forward in the arbitration after that, they're going to earn a very nice pay rate at the end of that day. The other thing is, they've got the issue of repeat business. And I have to tell you that there have been studies done where arbitrators, former retired judges, who have actually honestly said, you know, you have to recognize the tendency that, you know, next week, next month, next year, I may see that corporate representative again, and that does weigh in on our thought process. You can't change that. You can't undo that imbalance of power with this bill. I would also like to talk with you all about some studies that have been undertaken, specifically a 2009 study. It was a national study on public attitudes on forced arbitration. This was funded by the Public Welfare Foundation, the Employee Rights Advocacy Institute, Public Policy. This was about 800 people nationwide, so I can't tell you how many were from Missouri specifically or any of your districts, but about 800 folks nationwide, 18 or older, all registered voters. And the outcome of that survey showed that in general, in the electorate, opposition to forced arbitration is strong, it's intense, and it crosses traditional gender and partisan lines. Okay? It's not just Democrats or Republicans, it's a bunch of folks in general, a solid majority, in fact, of Americans, 59%, who were opposed to arbitration in this setting that we're talking about now, where an employee has to arbitrate the workplace dispute in order to keep or get their job. Just a little while ago, we were talking about the equal pay bill, about creating some guidelines that could be established in that area. And it was interesting because our friend from the Chamber of Commerce at that point, when he spoke, was talking about, well, you know, we do have these laws on equal pay in Missouri already, so, you know, whether there's a problem or not, I guess if somebody has that dispute, they can still go to court and resolve that. Under this bill that's in front of you now, if that employer had an arbitration agreement in place, it essentially would do away with that person's right to go and challenge their equal pay disparity. And that affects employees across the board, whether they're hourly folks, whether they're military service members wanting to protect their rights, whether they're a high-paid CEO, okay? None of those people are going to have the same bargaining power if they are forced to endure the arbitration agreements that are being proposed as this bill puts them in front of you today. So therefore, we respectfully oppose the bill. If anyone has any questions, I'd be happy to address those.
Representative Weber.
Mr. Chairman, in my traditional role, I'd like to ask queries.
Go ahead.
Can you go over the reviewability of arbitration decisions? Do you automatically have a right to take them to the court? Can you put clauses in there that say that this arbitration is final and it reduces your ability to appeal?
Yeah, and I think that Representative noted the way that the bill is constructed currently, it is the arbitrator who decides up front if it's going to be valid or not. I guess there is still the wiggle room on the back end that either party, unless they write it into the arbitration agreement, otherwise could appeal it. And frankly, I've actually seen them written so that it goes something like this. We're going to make you arbitrate. We might win, we might lose, we being the company. But if the company loses, we have the right to go to a court and say what happened to the arbitration is not fair. But guess what, employee? You don't have that right.
So it can be written into the arbitration agreement that you can't appeal.
Yeah, and I don't want to speak for you, but I don't think this bill speaks to that. It doesn't require that at this
Right, it doesn't require that, but I'm saying it can be currently. You you can put in the arbitration clause, sort of a final judgment clause that says this decision will be final. And that's currently in the status quo. What this bill does is has the arbitrator decide up front, and has the court even say, no, the arbitrator has to decide whether this should go to arbitration, and sort of via that mechanism, you could end up with people not having an ability to get to court. Is that accurate?
Exactly right.
Okay, and what are the consequences of not being able to get to court? What are the differences, in terms of procedures, things on the record? Why is it important for somebody to be able to get to court, and what is the impact of not being able to get to court?
Well, arbitration is fundamentally a closed process. So you all know that things are not perfect in the workplace. Bad things happen sometimes. And if we essentially rubber stamp the arbitration process that's being proposed here, none of those things are ever going to see the light of day. So if you have, say I'm, giving you kind of worst case scenario, if you've got a chronic sexual abuser in the workplace who's in a position of power, and the company keeps having people in their workforce, abused by this person, go through arbitration, pay them off, it's quiet, no one ever knows. You can keep that person in the workplace for as long as you want to without that kind of public accounting.
There's never a record established.
And then we think that that's fundamentally unfair.
If the rule of law is misapplied, if I feel it's misapplied by a judge, I can appeal that. If I feel it's misapplied in arbitration, and there's a clause in it that says I can't appeal,
Right.
do I have an alternative, or do I just have to live with that
That's
application of law?
exactly, and that's why it's fundamentally unfair, because you can have, in an arbitration, you don't have to have rules. I mean, he spoke earlier about, sometimes you say, this is who our panel is going to be. Again, that's being decided on the front end by a company. You don't have, Joe Smith talking to him up front about who should we have arbitrated. 2 years from now, I want to argue that I'm not getting paid enough. But yeah, and the problem is that there's no streamlining for, if you're an arbitrator, do you have to know the law? Do you have to apply the law? You don't.
Gotcha.
Thank you.
Thank you, Mr.
Very much. Other questions?
Just quick.
Representative Burns?
Thank you for being here. Do you make as much as male lawyers in your law firm?
You know what, I wanted to think about that when you asked that question earlier, because I've worked at my law firm for 10 years and I'm not a partner. I'm a counsel.
You better go to arbitration and get that done. Anyway, I appreciate what you're saying, and I think there's always a conflict. I mean, Representative, I think you probably know that as well. You own a business, you're a worker, there's always going to be some sort of conflict. I mean, we never had negotiation with the school board that was always meet and confer. Teachers and everyone, and for 12 years it was always the same story. We haven't given us enough money, or I don't have fair working conditions, and all those kind of issues. And that's what I'm assuming you're trying to accomplish. That's what you're saying, basic fairness in the workplace, where people can work and have a good living and not have to worry about these situations. Thank you very much. Thank you, Mr. Chairman.
Thank you. Representative Bratton?
Joe Quire. This is a question towards the representative. Now, all right, well, I'll just ask afterwards, so thank you.
Other questions? Thank you for your testimony.
Mr. Chair, I think we've got other people that will address many of the issues. If I could address Mr. Weber's question about whether the law provides.
Representative, that's not decorum.
Okay.
Questions and answers for the bill handler down at the beginning of the hearing.
Okay, thank you.
Those in favor of the legislation?
Good afternoon, Mr. Chairman and members of the committee. My name is Janet Mark. I'm Associate General Counsel at Hallmark Cards, and I'm here in favor of House Bill 928. House Bill 928 is an amendment to the Missouri Arbitration Act, and it provides for fair arbitration agreements for resolving employee disputes. and employer disputes, so regardless of who brings the claims. Arbitration agreements are becoming increasingly popular in the United States because it offers very many benefits for both employer and employee. First, it saves taxpayers money and helps an overburdened court system because it is funded primarily by the employer. It's cheaper and faster for the parties. Typically, an arbitration hearing occurs within 6 months or so versus 2 years for a lawsuit. And the discovery process is streamlined. Another benefit, the same remedies available in the court system is available in arbitration. The arbitrator can award whatever penalties, whatever awards he or she wants to and feels is appropriate. Another benefit is the informality of arbitration. A lot of times a courtroom is very intimidating for both the employee and the employer, and arbitration hearings, for the most part, occur in a conference room. The scheduling of the hearing is based on what the party's availability is and the arbitrator's availability. And the rules of evidence and the rules of procedure are relaxed in arbitration. There is greater predictability in arbitration. Juries have a tendency to act on emotion, whereas an arbitrator is a trained professional specific to the legal issues. In arbitration, a hearing on the merits is more common than in court because parties are less likely to file for or obtain summary judgment. And finally, arbitration provides a confidential forum for the parties to resolve their differences. Recognizing these benefits, the United States Supreme Court has expressly said that arbitration agreements are favored in the law, and has issued a series of decisions that affirm arbitration in both the employment and consumer context. Other states and federal courts, including those in Missouri, have followed suit, recognizing the benefits of arbitration, and routinely enforce fair arbitration agreements. The situation is starkly different in Missouri, in the Missouri state courts. Over the last 8 or so years, the Missouri state courts have eviscerated long-standing legal principles, including those relating to at-will employment, and have created a moving target of what, if anything, is enforceable under state law. And in doing so, they have acted in an anti-business fashion. It's a who's who of employers in Missouri who have had their employment arbitration agreements struck down or not enforced. And those employers include Anheuser-Busch, Blue Cross Blue Shield of Kansas City, the Kansas City Chiefs, Bristol Manor, McBride and Son Homes, Cintas, and Hallmark. House Bill 928 is an amendment to the Missouri Arbitration Act and does basically 2 things. First, it takes jurisdiction away from the state courts in deciding those issues of initial arbitrability. Basically, is there a fair contract? So the arbitrator does make that decision, so a forced or coerced agreement to arbitrate is not going to be enforced by an arbitrator. The second thing House Bill 928 does is sets forth factors for the arbitrator to consider when deciding whether an agreement is enforceable under Missouri law. I strongly urge the passage of House Bill 928 to provide for fair arbitration agreements in the employment context, again, for both employers and employees, and to curtail the Missouri State Court's activism and hostility towards arbitration agreements. Thank you.
Thank you. Are there others in opposition of the bill?
Chairman. Good afternoon. My name is Jonathan Burns. I'm a plaintiff's employment lawyer in St. Louis. I'm here on behalf of St. Louis NELA as well as MATA. And I strongly oppose this bill for two very basic reasons. One is the bill, as proposed, throws out decades of basic and the most fundamental of contract principles, that two parties have to agree to something before it can be enforced against them. And second, that this bill is something that imposes incredibly unfair, potentially unfair arbitration clauses on employees. And it's important to understand that these types of agreements are not your typical contract that is being negotiated by two parties of equal bargaining power. Representative Burns, you talked about the union context. This is fundamentally different than the union context. Most times, arbitration agreements in the union context are part of an overall collective bargaining agreement that has been where the union is negotiating with the company and has relatively equal bargaining power. In the non-union context, though, where this normally comes up is when an employee or an individual is just starting to work with the company, and the company unilaterally drafts an arbitration clause and gives it to the employee. And it's taking advantage of a Missouri worker in one of their most vulnerable spots. They're being asked basically to agree to a contract or a arbitration clause that the company has drafted, or give up their job and not be able to pay their bills or put put food on the table. And a lot of times these are agreements that are being given to employees who are longtime employees that work for a company for 10, 15 years, and then being asked to agree to this or give up their job. The idea that some of the testimony we've heard here that arbitration is some fair process, quite frankly, is a fantasy. Under this bill, there can be agreements that are fundamentally unfair and essentially deny Missouri workers to any access to justice. Under the statute, if an agreement is deemed valid if it meets certain criteria, but those criteria do not speak to at all whether or not the arbitration clause is fair or reasonable. For example, an arbitration agreement, a company could draft something that says, employee, anytime you want to sue us, you have to go through arbitration, but anytime we want to sue you for anything, we can go to court. It can be one-sided like that under this bill. Under this bill, the Missouri employer can pick the arbitrator. They can say the arbitrator is somebody who we unilaterally select. It could be the CEO's mother. It could be the CEO himself. And under this agreement, the arbitrator would have to deem this valid no matter how the arbitrator is selected. How does that provide an employee an opportunity for justice if they've been wrong? Under this agreement, the employee could be required to pay for the arbitration process. Maybe come forward with $10,000 or pay for the attorney's fees of the employer. Clearly, that type of financial requirement would deny most employees the opportunity to vindicate their rights. But under this bill, that kind of contract would be deemed valid if the company gave that to them in writing at some point. In this day and age, if those types of provisions are in arbitration agreements, you go to court and a judge says that that's unconscionable. I think common sense would dictate that. But the way this bill is drafted, those fundamental rules of fairness have been eliminated. The other big issue I have with this bill is that it throws out the requirement of acceptance. You can impose an arbitration agreement under this bill on an employee even if the employee hasn't agreed to it or hasn't even seen it. In this bill, if an employee, for example, receives an arbitration agreement and the employee reads it and says, I don't agree to that. And the employee's manager says, well, I'll get back to you on that. And the employee comes into work the next day. Under this bill, under the language of this bill, that arbitration agreement is now enforceable against the employee, can be opposed against them. Because under this bill, if they've provided the agreement in writing and the employee works yet another day, that's automatically deemed acceptance under this bill, even though the employee has expressly said, I don't agree to this. Another common example would be an employer gives the employee a 250-page employee handbook, and buried in the fine print in the middle of that agreement is the arbitration clause. And that diligent employee goes home that night, starts to read through the employee handbook, gets to maybe page 50 before he falls asleep. Comes into work the next day, hasn't even seen the arbitration provision, but continues to work. Under this bill, even though the employee hasn't seen it, hasn't read that agreement, it can now be enforced against them. That just seems fundamentally unfair as drafted, this bill. If you want to pass a bill that's going to regulate arbitration agreements, you need to do so in a way that ensures that there's fundamental fairness in that arbitration agreement, and that you have a situation where an employee has actually had a fair opportunity to review it and agree to it before it can be enforced against them. For those reasons, I oppose the bill as drafted. Thank you.
Thank you very much. Are there others here in favor of the bill?
Mr. Chairman, members of the committee, Ray McCarty, President of Associated Industries in Missouri, here in support of the bill. We think we support arbitration agreements and believe they should be pursued first. The employer and the employee have agreed to that up front. And that's what this says. I think also to address the questions from earlier, that if the arbitrator has in fact prejudiced the arbitration on behalf of the employer, that cannot currently be appealed under 435-405. So that is not being changed by the bill. And Section 435-405 also allows appeals if it was corruption, fraud, or if there were undue means. So you have to answer your questions. They can still appeal that to court.
Thank you, sir. Others in opposition?
Mr. Chair, members of the committee, Otto Page on behalf of Missouri MEA. I'll be very brief. The previous witnesses have given testimony which we are substantially in support of. Our concern is with regard to our at-will employee members, which would be support staff, that this might be used in ways that are not fair to their right to justice for discrimination concerns. But actually, I think we concur with pretty much all the testimony that's been heard, because what we heard from the proponents was the support for proper use of arbitration, which we agree with. And so we think there probably is opportunity to draft a bill that would meet all of the concerns that have been addressed for, and we would encourage the committee to seek to do that. We don't believe that this bill, as drafted, addresses all the concerns. I'd be happy to try and answer questions.
Thank you, sir. Others in favor?
Thank you, Mr. Chairman.
I'm Susan Henderson Moore, lobbyist for J.E. Dunn, and we just want to go on record in favor and echo the other proponents.
Thank you very much. Those opposed? Any others in favor?
Hi, Mr. Chairman, members of the committee. Fred Riley today representing Burns and McDonnell Engineering in Kansas City, and we too would like to go on record in support of the bill.
Thank you, sir. Any others? Are there any here who want to speak for information purposes only? Okay, none appearing. Seeing no further witnesses, that concludes the hearing on House Bill 928. Thank you, Representative Corley.
Thank you, Mr. Chairman.
Thank everyone for coming today. Appreciate you.